Good afternoon. I'll call the Committee on Civil Law and Data Practices Policy Committee to order, and today is Thursday, February 24, 2022. We have two bills on the agenda today. First one we'll hear is Senate File 1226 from Senator Anderson. Senator Anderson, welcome to the committee.
Thank you, Mr. Chair. I appreciate the opportunity to testify on Senate File 1226 before your committee and my committee. I guess I'm part of this committee. So I want to bring this forward. Senate File 1226 says, and kind of near and dear to my heart since I have a special needs child myself, but was contacted by the lady who contacted my office several years ago about concerns for dealing with, and she'll talk more about it in her testimony, but some of the concerns with family and dealing with her special needs child. But it's specifically dealing with developmental disability for parents who have these children, and this crosses a wide spectrum of parents and families across the state of Minnesota. And it touches near and dear to my heart too. Didn't realize in talking with my testifier and then talking with her lawyer that there were things missing in statute right now that wouldn't help her and her situation, but realized after talking with her and talking with others that it not only touches her life and her family's life, but also other families across the state. So, Mr. Chair, I appreciate the opportunity to present 1226 regarding best interests of the child in custody and parenting time determinations, and I would like to just turn it over to my testifier and have her come and speak to us about her need.
All right. Thank you, Senator Anderson. Our testifier is Ms. Karina Sarsland. Welcome to the committee. Please state your name for the record and then feel free to begin. Welcome.
Thank you, Karina Sarsland. Thank you, committee, for having me here today. This is my 11-year-old son, Trey Sarsland. He has Down syndrome, and I'm a middle school science teacher, and next year will be 30 years in education. We live in Rockford, and Trey attends school at North Winds in Buffalo. Trey's father and I were never married, and the court order requires documented communication via our family wizard, and I have sole physical custody, and we have joint legal custody. When visitations happen, Trey is not getting the supervision care he requires during his visits. Medical, physical, psychological needs are not being met. I will share how supporting Senator Anderson's bill would impact our lives and the lives of others in our situation. Trey Sarsland has Down syndrome, as I mentioned, hypothyroidism, and apraxia. He is prone to upper respiratory infections and dysregulation. To quote Dr. Tiffany Cobb, the Gillette neuropsychologist, it's important to parent him as if he's a 2 to 3-year-old, as this is how his brain interprets information. Trey requires structure and consistency to feel comfortable. When there are too many demands placed on him, he's likely to become anxious and dysregulated. He takes levothyroxine daily, and his blood is monitored for cancer due to the type of Down syndrome he has. Trey was born at an emergency C-section a month early, and he spent the first 3 weeks of life in the NICU. Trey's IQ score of 49 is considered severely moderately handicapped or intellectually handicapped. On a daily basis, I bathe him, dress him, brush his teeth, remind him to use the bathroom, assist him in his speech development, feed him, clean his glasses, cue him on transitions, provide activities that stimulate his growth, dress him, prepare him for bed, and maintain a calm and positive approach. Scheduling therapies for speech, PT, OT, assist in his development. Following the court-ordered visitation time has caused severe stress on Trey. Unfortunately, even doctors' recommendations aren't followed at visitations and have placed Trey in danger. During the last 11 years, I incurred $30,000 in legal expenses. These fees began when I was with the initial request of parenting rights and forced us into the court system. Every 2 to 3 years, I was forced into hearings and mediation as Trey was never able to fully meet the level of visitations, which had no degree of differentiation granted by the court. Along with the lack of accountability on his father, such as he not attending required anger management therapy, not following up after doctor visits, relocating 4 times, these were choices out of my control that created a financial cost. I replaced 3 vehicles due to dysregulation during visitation. Dysregulation for Trey consists of vomiting, wetting his pants, or losing control of bodily functions due to anxiety he has experienced. These children are not experiments, as a PACER advocate once said at an IEP meeting. Often they will internalize the anxiety until they feel safe enough to release it. Numerous hospitalizations and doctor visits have impacted our lives. An unfortunate incident that still haunts me is through the court documents, realizing that his father had allowed Trey to wrestle with older cousins during visitations, which was in direct conflict with the Down syndrome specialist recommendation not to allow it because they basically have a weaker neck structure. This could cause paralysis. It was obvious that preventive protection for Trey's health and safety needed to be increased. As even in the first year of Trey's life, he was in and out of Children's Hospital due to viral pneumonia and T cells in his immune system not forming properly, and unable to fight illness as well, creating the need for a respiratory care plan. I was constantly trying to meet his needs in spite of obvious communication from his father and our family wizard, like, do you crush the penicillin as you do thyroid medication when Trey's in the red zone? When I wasn't given Trey at a visitation pickup, I had to purchase a cell phone and have my father as a witness to what was happening. Fortunately, my father, Carol Sarsland, recently died of COVID. Fortunately, not until after he and my attorney, Chad Tronstead, had a heated conversation in the summer of 2020, which enlightened me with the knowledge of the loophole in the law that we desperately need supporting. In closing, in order to get out of this vicious cycle and protect the disabled children like Trey, this motivated me to reach out to Senator Anderson, who in turn with his staff drafted the bill you're reviewing today. In Trey's case, a legal guardian would need to be able to comprehend and explain the conditions of hypothyroidism, apraxia, upper respiratory infections, treatments, and the impact of prednisone steroids on a child. This is support that his father is unable to provide these due to his own cognitive disability, and it's not something he will ever be able to provide for Trey. Dysregulation and rationale for blood cancer screenings would be vital to understanding of maintaining Trey's health. Bathing, dressing, grooming, and maintaining doctor visits, auditory wellness visits would all be required. Having foresight to dangers, cueing Trey for successful transitions needs to be second nature, and understanding his IEP goals and their implementation would be negotiable. Preventative health choices in addressing both Trey's physical and neuropsychological needs are required for Trey's health and well-being. Showing comprehension of dysregulation and medication delivery would be a necessity. Trey cannot verbalize his needs. He doesn't speak, which places an even higher standard for competency and a legal guardian. Following doctor's orders is a health and safety requirement for special needs children like Trey. If a parent receives a below average score on a court-ordered intellectual competency test, that needs to impact the discretion of visitations. I'm asking that the court must be able to consider all of Trey's needs, including those created due to this developmental disability, in order to ensure he can safely be cared for by a parent. So the purpose again of this document is to testify and provide the committee a lens through which the current law has impacted our lives. Several of their parents through both PACER and Facebook voiced their support of this bill. These children need us to responsibly be the voice of advocacy and protection. Please add the important wording of developmental disability to the law in order to rectify and acknowledge the best interests of the children in these gray areas who have had significant impact on their lives. Thank you, Chairman.
Ms. Sarsland, thank you. I appreciate you sharing your testimony and your story, and you help us picture your scenario that many of us don't comprehend ourselves. So I really appreciate you coming down today and sharing with us. Senator Anderson, do you have any more follow-up or comments to make?
Mr. Chair, just to let you know that the lawyer that Ms. Sarsland has been working with, his testimony is in your packets, I believe. So if there's concerns with the language that has been presented in the bill, he has kind of outlined some of his concerns as to why he needs this language to be able to help her and others in their situation. So that's basically what I have to offer for more insight.
All right, thank you for pointing that to our attention, Senator Anderson. We'll go to questions from the committee. Senator Bigham.
Thank you, and thank you, Ms. Sarsland, for your testimony. And, you know, I really empathize with you, and you can tell by the passion in your story that you never mess with a mother. That's all I know. And so I think this is definitely something that needs to happen, and I think it's very logical when you think about whether it's the dissolution of a marriage and dealing with custody or in your situation. So I think this is important that all of these individual situations be, whether it's according to current statute, special medical, mental health, or educational needs, and all this bill simply does is inserts developmental disability into that. And I think it's an important consideration that the courts and the state should recognize. So thank you for being here today, and thank you for sharing your story.
Thank you.
Thank you, Senator Bigham. Senator Limmer.
Thank you, Mr. Chairman. And thank you, Ms. Sarsland, for coming down to the Capitol today. Perhaps my question is either for Senator Anderson or to our council. Traditionally, we give judges a fairly wide berth to use their own discretion on determining decisions. And oftentimes, as you can see in the existing language that's in statute, we give suggestions, or not even suggestions, we give direction to a judge to consider certain elements before they make a decision. And in this case, we're adding one of those elements for a judge to kind of force him to take account. But I guess the question I have, and we deal with this very often, and we don't always pass it because we believe in judicial discretion. It's a common element here. Is there a problem with judges that don't recognize development disability? I would like to know if there's a history to that we now have to put this category in law in order to make a judge try and understand or to fathom this condition.
Senator Anderson.
Thank you, Mr. Chair. Senator Limmer. In talking with his lawyer, her lawyer, I should say, excuse me, they basically said going into courts to help her in her situation with the biological father in this situation, that it wasn't really taken into consideration, and that he felt as a lawyer that these words needed to be included. I would give Ms. Sarsland maybe an opportunity to discuss this, because she was in the courts more than I was at the time. So I just listened to what they had to say, and I appreciate what she would have to say to add to this.
Ms. Sarsland.
Thank you, Chairman. I feel like I was addressing this with Senator Anderson as I was writing my testimony, and I said, Chad, can you please address the point where we came to the roadblock? And that was, I said to him, developmental disability, we're not looking at his health, his maintaining of his dysregulation, his throwing up, and that was as equal value of, am I seeing a relative, am I, attending school? Like, to me, Maslow's hierarchy is about like self, being safe and healthy and well-being. And if that wasn't the case, I wouldn't have even brought it here. But because it wasn't even just the level of where that should be. And when my dad was so upset and they were talking, he said it's because of this loophole. The judge doesn't have to look at it. And by doing this, I just think it's like you don't know what you don't know. And so if you don't address developmental disabilities as you're preparing, a judgment, I just feel like the PACER advocate said, just giving them the opportunity to consider all of Trey's needs, including those created with a developmental disability, in order to ensure his safety. And to me, sir, that's why I would bring this to you.
Okay, thank you.
Thank you.
Any follow-up?
No.
Okay. Senator Bigum.
Thank you, and I think also part of it is that the court looks to medical, like health issues, and they weren't considering it as like parity to developmental disability. So they weren't considering that, I think is kind of what the lawyer is alluding to in his statement that's in our committee packet too, which I think people could understand how that might impact a custody schedule in that regard.
Thank you. Senator Latz.
Thank you, Mr. Chairman, and to the witness, thank you for coming down here, Ms. Sarsland. Looking at you through the technology here, I'm sorry, but that's just the way the seating arrangement is set up. I was closer to your son when he was over here, so. But thank you for coming down here and sharing your important story and your experience. It's helpful to us to learn that. I'm reading through the bill and the statute, as the statute is currently written. And I guess I have two questions. One is, and probably not for you, Ms. Sarsland, but more for Senator Anderson as the chief author of the bill. Senator, have you reached out to the various stakeholders that have been involved over the years in family law amendments or changes in statute? I mean, we did a major overhaul in 2015, which was a product of many years of input, discussion, negotiation, mediation with, I don't know, maybe a dozen different stakeholders, the State Bar Association, Family Law Center, the Matrimonial Lawyers Associations, a whole bunch of different people that were involved, organizations that were involved. Have you gotten any input from them with regard to this proposed change?
Senator Anderson.
Mr. Chair, thank you, Senator Latz. No, I've not talked to anybody, but because I have a special needs daughter, I am in contact with PACER and with other organizations that have talked about the special needs of a child such as mine and such as Ms. Sarsland's and others. I've not specifically talked about this bill to them, but realize that when in a situation with Ms. Sarsland and a biological father are involved, there are complications sometimes that deal with the courts. And dealing with that, they have expressed to me, not specifically on this bill, but they have expressed to me that sometimes it gets overlooked as far as the need to meet these situations in their families. So I'm not specifically about this bill, no.
Senator Latz.
Thank you, Mr. Chairman, and maybe to the chairman or the committee staff. Has the committee received any input regarding this proposal from any of those stakeholder groups?
Yes.
Sometimes they reach out and submit letters indicating they're fine, they're not fine, they take no position.
Yeah, thank you, Senator Latz. No, we have not had any of those groups contact us to discuss this bill. This was introduced in February of last year, so it's been out there in this session for a year. We had no one reach out to talk about the bill, and then since it was posted, no one reached out with an interest in testifying to it either. So it's been pretty quiet on that front.
Mr. Chairman, if I may ask, when was it posted for this hearing?
I believe we had it at least Monday. I'm going off memory here.
I think I said earlier. Thursday.
Okay, couple things were posted. We'd have to check if a Zoom link or a meeting notice went out Monday or yesterday, but those are the options that we have that we can check on, Senator Latz.
I'd appreciate it. And also, what is the chair's intent with regard to what to do with the bill here today?
I am planning to have a vote to send it out to the floor at this point, and there's no other, it's to the floor, correct? Yeah. Passing it on as a standalone bill to the floor.
All right. Mr. Chairman, I'm also, in reading the statute here, I guess I don't read the statute the same way that the lawyer who submitted the written testimony of Mr. Thronset does. I know, sound like Senator Anderson spoke of the fact that that input came from a lawyer with a certain degree of reverence. Perhaps that's how I detected it. I'm not sure that, well, I obviously respect lawyers, because I am one. I rarely give reference to their opinions, because you put two lawyers in a room, you can get three different opinions. And the way I read the statute here, that's already in law, and it's reprinted on lines 1.9 and 1.10 of the bill before us. The court must consider and evaluate all relevant factors. So that's an enormously broad statutory guide to the judge, all relevant factors. So it doesn't exclude anything. Then it goes on to say including, and it lists a bunch of different, subparagraphs, 12 subparagraphs, listing all the different things there, and I haven't had a chance to read through all of them, but the place where this is proposed to be included is on the paragraph 2, the special medical, mental health, or educational needs component, inserting development disability in there. There might have been some reason that the legislature itemized the considerations that the court must include, but that itemization is not exclusive. And so I read this as saying that at least under the statute, unless there's some case law, which is why it's helpful to get input from, say, the Bar Association Family Law section on this, unless there's some case law to the contrary, the statute already requires the court to evaluate developmental disability of the child if it's relevant to the parenting time or the custody determination. And while adding this to the statute may not do any harm or change, help, it might not hurt anything. I'm not sure that it necessarily helps, except it sort of lifts it up, I guess, more into the open, if you will. If Mr. Thronset was involved in court regarding the child whose experience is before us now, I'm sure he pointed out to the court that there are developmental disabilities involved here, and the court should consider those in determining what to do as well. And in fact, if he had cited the statute, he would have said the court's required to consider those factors. And maybe the judge didn't give the consideration or the priority to those factors that Ms. Sarsland thinks would have been appropriate. But I'm not sure I want to stand in the shoes of an individual judge seeing the facts of a family or a child and the two biological parents in front of that judge to make a decision in that judge's place. So I'm trying to weigh this here as to whether it makes sense to add some statutory language that I'm not sure if there are going to be unanticipated consequences or maybe anticipated, just not by me or some of us in the room because we don't practice family law or not deeply familiar with the case law on the subject. And I wouldn't want to cause any untoward consequences either. So I guess my suggestion here, although I'm completely sympathetic to the situation, and I would think it would be a factor that was considered by the judge, I'm wondering if maybe it makes more sense to give some of the other stakeholders an opportunity to weigh in here. I am told that the first notice of the hearing today with this bill on it went out on Tuesday. I'm not sure if it was posted, the email anyway went out on Tuesday. I'm not sure if it was posted online before then, but the email went out on Tuesday, and I know the committee maintains an email list of stakeholders that have requested to be notified of the agendas and so on. So it sounds like they had sometime on Tuesday, maybe a day and a half notice to decide if they wanted to weigh in, go back to their organizations, decide if they're going to offer advice to the committee on how to handle this. So it might have been a little bit quick, especially if the bill's been lying dormant for a year in committee up until now, without any attention being given to it in the last year anyway. So I think if we want to make sure we have well-informed input before making a decision like this, even though I am very sympathetic to the situation, I'd like to be better informed before I vote to pass it onto the floor. And there isn't, normally, we don't like to send bills out of this committee anyway that aren't ready to become law, even if they go into another committee that doesn't have the kind of jurisdiction or the expertise we have on this committee. But especially if this is going directly to the floor, I think we ought to make sure we conduct our due diligence here before we make that decision. So I'd ask the chair to consider laying this over, maybe giving another opportunity. It wouldn't require Ms. Sarsland to come back and to testify again. We've all got that and we've heard that. But I'd really like to hear the input from stakeholders, especially family law specialists, as to what impact this might have before I make a decision on it. Thank you, Mr. Chairman.
Thank you, Senator Latz. And yep, I was going to say that I got confirmation it was Tuesday that we had this hearing out, so I wanted to make sure that our record reflected that. So I appreciate that. Is this to this point, Senator Bigham? Okay, Senator Bigham.
The other thing I just noticed, because, you know, as paralegals, pay attention to detail. It was introduced on the 22nd. And so
No,
to
of a year-
Senator,
Of
a year ago,
2021.
2021.
well, that didn't age well, did it?
Quite all right, Senator Bigham. Senator Carlson.
Yes, thank you, Mr. Chair. And, not being a lawyer, and actually this particular experience makes me thankful of that. I have had some experience with parents who feel that the courts have not been fair to them in especially custody issues, and I think we all know that there's really often only one side that feels that anything has been fair. And I fell into a particular incident that I won't get into too much detail on it, but because it involved a judge that used to be on the Senate floor, was a senator and was appointed by Governor Pawlenty to be a district judge. And I reached out to him to ask him about a particular custody case. And one of the, I guess what he had advised me strongly is he said, Jim, you don't want to be involved in this. Trust us. The judiciary knows what they're doing. Trust us, trust us. And actually, the reason for me reaching out was I thought maybe one side was not being treated well. And I listened to that side for quite some time and found out that there were other issues involved. And that's why I reached out to the judge. And I found out, now this was actually a case from Dakota County that eventually wound up sending someone to prison. And I was wrong in my first assumptions. And the judge, DK, he was absolutely correct. Keep your nose out of it, Jim, because we know what we're doing. So I want to make sure that, like Senator Latz said, that we get a balanced description of, and especially here where we're talking about mandating a judge do something that I think they're supposed to be doing anyway. I think they're mandated to do it anyway. I really don't feel comfortable as well without hearing maybe a little greater side of this. And I want to make sure that I know that whichever way I vote is going to be backed up by some broader acknowledgement of just what the situations are. So thank you, Mr. Chair, for letting me give that opinion.
Thank you, Senator Carlson. So my plan today will be, since the bill has been out for a year, I do routinely get inquiries into my office on bills right after they've been introduced, without, before decisions have been made on hearings or not, just as here's a heads up of what we have on this bill. Since I've not gotten that on this bill for the last year, I will intend to proceed with a vote and pass it out today. If I get any sizable concern from any family law groups or other groups, I will pull it back into committee here and give them the opportunity to explain that. but that's gonna be, my intention today. So, any further discussion on the bill? Senator Limmer.
Mr. Chairman, thank you. My first question was whether or not judges had the knowledge of considering a new factor. But that's not to ignore the other factors that are in existing law. And as I look at this, it'd be interesting to know the history of this particular statute. There's 1, 2, 3, 4 separate paragraphs with a variety of different elements that a judge should specifically look at, or at least highlighting. Maybe the word is highlighting those elements. And there has to be a reason why that these are written into statute, despite the fact that there's a reference or a direction to evaluate all relevant factors. When I look at some of them, the obvious ones that I see in the first paragraph, physical, emotional, cultural, spiritual. If you go down to number 4, the physical and emotional certainly could tie to a domestic abuse that you see on line 18. And I would think that perhaps a judge would automatically think that physical, emotional issues would follow if there was domestic abuse. And so oftentimes, I look at this as a reference or a direction to the courts. Consider all relevant factors, but be sure to include things that you may overlook. Like, I guess I would call it maybe a refined focus, that we as a state are giving direction to the court to focus on. It's not, I don't think it favors a particular plaintiff or a defendant in either case. I think it's, for lack of a better term, maybe a little checklist for a judge to consider. And I don't think that the terms developmental disability does damage to the statute. I do have a great deal of respect for judicial discretion. We're not asking the judge to make a decision. We're just asking the judge to consider, especially consider. And so for that purpose, especially with the bill being in existence for a year, I'll support it. And I'll be anxious to see if it surfaces any other claim before it goes anywhere else. Mr. Chairman, I would suggest you give specific direction to the people that schedule bills on the Senate floor to pause so that anybody out there that has any added concern could reach you. And I would suggest we move forward with the bill.
Yes, thank you, Senator Limmer. That will be my intention. Senator Latz.
Mr. Chairman, what's the rule with regard to giving notice for hearings that bills are going to be considered? My recollection is that the rule is 72 hours in advance of the hearing date, except under unusual circumstances, but I can't imagine we're under any unusual circumstances here, that there's any urgency to be moving along with a shorter time period than that.
Yep, Senator Latz, the rule states to the extent practicable, 3 days is the normal time frame of the hearing. And we try to meet that as many times as we can. Hasn't always met that standard, but that is our intent to be meeting that rule.
Well, Mr. Chairman, I guess I'm trying to figure out what wasn't practicable about this bill, that we couldn't give at least the 3 days' notice. That would be the ordinary amount.
Any further discussion?
I guess I was asking a question, Mr. Chairman.
Yeah.
What was impractical about giving 3 days' notice instead of 2 days' notice here?
There was no distinction in this case for it being Tuesday instead of Monday. It was how it came together on the staff end of things in my office through the committee. And we had the testifier scheduled on this day. And in the future, we'd be intending harder to meet getting these posted on a Monday versus a Tuesday in cases like these, Senator Latz.
Mr. Chairman, thank you. I think it's the only way to maximize the ability of the public to participate in our legislative process. I mean, the shorter the notice, the less likely they can participate. Even if we have Zoom now and they can not have to schedule a half a day or a full day off from work to travel to the Capitol to participate, they still need to have appropriate notice. And I don't think this is the first time that this has happened with regard to bills and civil law. So I hope it's the last time, so that we don't have issues of the public being denied the opportunity as a practical matter of weighing in on the legislative process. I have one other concern about sending it to the floor. You know, Chapter 518 is it's pretty kind of a lightning rod for a lot of people who are interested in family law issues. And I'm a bit concerned about the risk of being able to open up a bill on the floor if there are any amendments that are suggested relating to this or anything else. So I guess I'd like to know what the intent is of the chief author and the intent of the chair, if there is any talk about or attempt by other interested parties to, or legislators, to offer amendments on the floor that relate to family law. I mean, what's the plan? Could this bill become a vehicle for anything else?
Senator Latz, from my perspective at this point, I think this is a narrowly scoped bill and intentionally left that way as we pass it out. So my intent, my push to the schedulers and to our caucus would be to let this travel through as its own standalone bill. We'd obviously have to discuss, every member has the right to offer amendments, and we'll do our normal planning for that ahead of time. But I believe the hope on my end, and I'll send it to Senator Anderson here too in a minute, would be to have this go to the floor as a standalone and have it considered on the floor as a standalone issue as well. And hope that members would take note that this being such a narrow scoped bill with what it's purporting to change, that it would not be the best vehicle for any type of other family law related amendment, at least would be my encouragement to our other members. Senator Anderson?
Thank you, Mr. Chair. Senator Latz, no, this bill is totally, the two words that we put on this bill is all that we were asking for, and nothing, there was no alternative motives behind it but to help her and other families in this situation, my family included.
Mr. Chairman?
Senator Latz?
I was not suggesting there were alternative motives, but I am worried about others who might try to take advantage of an opportunity. I wonder if the chief author would be willing to give a commitment that if there are any attempts to add anything to this bill on the floor that are unrelated to the specific two words in the bill,
Mr. Chair.
that the chief author would withdraw the bill from consideration on the floor.
Mr. Chair, Senator Latz, I will try to do my
Senator
best.
Anderson?
Well,
But there are people, all of us, who have the opportunity with a certificate that says otherwise. But I will try and keep it as clean and packed, intact as it is right now today.
Mr. Chairman,
Senator
the
Latz?
chief author of a bill always has 100% control of their bill in that regard. They can, at any time in their sole discretion, withdraw the bill from consideration on the floor. So
I'll consider that, Mr. Chair.
I'm not hearing much of a commitment there, Mr. Chairman.
Senator Latz, hopefully you join the author in voting the same way the author does on any amendments that would come on the floor. That would definitely play a factor in it as well.
It's
It's the same kind of commitment you're asking of Senator Anderson at the moment,
No,
too.
no, it's not at all. If Senator Anderson wants this bill to become law without controversy, he'd be willing to make a commitment right now that he's not going to let it become a vehicle for any other interests relating to family law reform in Minnesota. And he's not willing to make that commitment now, I'm reluctant to send it to the floor for another reason, which is that one now, because Senator Limmer, who has stood a very hard line before the committees were divided between judiciary and public safety and civil law, I would expect would share my concern with regard to making sure that any other proposed reforms of family law went through the committee process and didn't pop up on the floor for a wide-ranging and emotionally debilitating debate. So I'm pretty nervous, actually, that Senator Anderson, for whom I have a great deal of respect, is unwilling to commit right now to say he's going to withdraw the bill if someone else tries to hijack it for a different amendment for a different purpose. So I'm not prepared to vote now in favor of a vehicle bill or a bill that might be hijacked as a vehicle bill down the road. One other thing, and this is a mandate to the courts. That's what this is. This bill is a mandate to the courts, and I kind of doubt we would hear from the courts directly on that, but I think it's even more important for us to hear from the lawyers who practice in this field before the Civil Law Committee of the State Senate passes a bill with a recommendation that it become law onto the floor of the State Senate. I think that's a terrible process, and I'd ask the chair to reconsider. Wouldn't take much to lay it over right now, bring it back up for 5 minutes in a week or two after the stakeholders have had a chance to either act or send a letter saying they don't care about it or there's no problem. It would take another, not even 5 minutes of committee time to move it out at that point. But it could take an awful lot of Senate time if there's a problem that arises later that we simply didn't give enough time here in the Committee of Jurisdiction to consider. So with that, reluctantly, if the proposal is going to be to move the bill to the floor today, just on procedural grounds, I'm going to have to oppose the bill. Thank you.
Thank you, Senator Latz. From my intention, if and when this comes up on the floor, I plan to vote no on any amendments that would be proposed to it. It takes 34 votes to attach any amendment to a bill. I'm getting a head nod from Senator Anderson. I expect he'll be doing the same way and encouraging other members to do the same. And that's the provision that we'll continue to move forward on today. And I'll just also note for the record that we haven't shut out anyone from this committee. We try to post as much as we can. We're going to keep trying to do even better in having an adequate number of days' notice that's out there. And nobody that is requested to speak to this committee has been denied. And that is my process with this bill and how I plan to continue to run moving forward. So I appreciate the discussion. Any further comments? Senator Limmer.
Mr. Chairman, I'm not sure if Senator Latz put it in an understandable way. I had a little difficulty in understanding the question that he gave to the chief author. Let me attempt to reconfigure the question. I think what really is the concern is that this bill subject involves parenting time and custody. And custody in this case is uniquely focused just on these two words. But custody means something else to parents that are in dispute over who gets custody of their child during a divorce, as a result of a divorce. And people that are wanting to reform that law, not this law, but that law, will see this as a platform to amend this on the floor of the Senate. It could be judged as non-germane because this is rather finite focus, but we don't really know how the President of the Senate is going to define that germaneness. So whenever we get a bill like this that mentions words like custody and children, it raises a lot of attention on both sides of that issue. And Senator Latz is, I think Senator Latz was, what he was trying to do was ask that if a major reform amendment got to a vote, not only would you oppose it, but if it went on your bill, then he was asking if you would lay the bill on the table.
Mr. Chair. Mr. Chair, Senator Lemmer,
Senator Anderson.
I would take and lay the bill on the table and leave it there.
All right.
Senator Limmer.
Thank you, Senator. And the reason I ask this is that this is a really good bill. By that direction, you're putting a signal out to the other parties in that other big issue. They're going to step down. They're not going to bother this. And this will go, well, it may still attract a little more attention from those that are practitioners in the field, but nevertheless, that one big reform issue will stay off this bill, and hopefully you'll get success in the Senate.
And Mr. Chair and Senator
Senator
Lemmer,
Anderson.
I hope that we don't have to put it back on general orders or have it pulled back into committee, but I'll try and keep it as clean as possible.
All right.
Thank you, Senator Anderson. Any final discussion? Any closing words from you, Senator Anderson?
Well, Mr. Chair, members, I just appreciate your willingness to take and listen to the bill and look at the way the courts are considering and evaluating all relative factors. We're just adding this one narrow part to that thing that the court should look at, child, an individual that has a special needs, disability, to consider that in their judgment as they make a final decision in the part of parenting, co-parenting, and helping that family get on with life.
Thank you, Senator Anderson. Thank you, Ms. Sarsland, for coming today, and thank you, Trey, for coming here and visiting us with your mom today. With that, members, Senator Anderson, would you make a motion on your bill?
Mr. Chair, I move that Senate File 1226 be recommended to pass and put on general orders.
Thank you. All those in favor of that motion, please say aye.
Aye.
Opposed, no. Motion prevails. Thank you, Senator Anderson.
Thank you.
Next bill up before us, Senate File 3214 from Senator Koran.
Thank you, Mr. Chair. I believe this is my first appearance before your committee.
You're drawing groans from the
I'll leave the
audience up here,
statements.
Senator
I'll leave the
Koran.
statements about attorneys to the side, Mr. Chair. I believe Senator Latz covered it earlier, so appreciate the support, Senator Latz. Mr.
Senator
Chair,
Koran.
would somebody like to move my bill?
Senator Bigham moves Senate File 3214, and I believe you also have an author's amendment to the bill, Senator Koran. Is that correct?
Yes, Mr. Chair.
Senator Bigham moves the A1 author's amendment. All those in favor of the amendment signify by saying aye. Aye. Opposed, no. Motion prevails. Amendment is adopted. Senator Koran.
Thank you, Mr. Chair, and I'll cover the highlights of the bill, and we appreciate your support. I'll cover the highlights of the bill, and then the amendment itself was derived out of the hearing to further clarify the bill language itself, and our testifiers will cover the particular changes related to the amendment. But this legislation is a change to improve the efficiency of the hiring process regarding access to background check information by allowing local governments to obtain background check information directly from their law enforcement agencies rather than going through the BCA. This bill does not change or create any new data requests or access processes for any of the involved parties, but improves the process for both city hiring staff and candidates for employment. It's a good government process bill. And so with that, Mr. Chair, we have two testifiers, and I'd like to toss it over to Ms. Alex Hassel.
Ms. Hassel, welcome to the committee. Please identify yourself on the record and then please begin.
Great. Thank you, Chair Matthews, for bringing the bill forward. And thanks to author Senator Koran for your work on the bill. My name is Alex Hassel. I'm with the League of Minnesota Cities, representing 837 cities across the state of Minnesota. This bill is really an efficiency bill to improve the way that city hiring staff, local government hiring staff, obtain background check information during the hiring process. Laura Kushner, the League of Minnesota Cities Human Resources Director, will share a little bit more on the specifics of the bill in a moment, but I did want to share that this language was created in collaboration with BCA to allow local government's law enforcement department to share criminal history information with their hiring officials rather than having them obtain a criminal history check on a candidate via BCA. I'd like to emphasize the point that this bill does not provide any new data that wasn't accessible under current law, nor do any new people get access to the data, but it is a process improvement to increase the efficiency of hiring for both cities and candidates. I can also share the two parts of the amendment. That this arose out of addressing a few concerns that came up in House Committee. The first part was to add the language hiring and licensing authority to who is authorized to receive the information. This is just to be more specific on who at a city or county can receive the information and to make consistent with other provisions in the statute. The second part of the amendment adds reference to 364.05, which requires that if a hiring or licensing authority denies any applicant for any reason pertaining to their criminal history check, they have to notify that individual. So that is the amendment. But with that, I'd like to thank you for considering this bill and pass it over to Laura Kushner.
Thank you, Ms. Hassel. Ms. Kushner, welcome to the committee. Please identify yourself and then begin.
Thank you, Mr. Chair. My name is Laura Kushner. I work at the League of Minnesota Cities as their HR director, and in that capacity, advise member cities on good and best practices in the field of HR. Basically, when cities need to do a background check on an applicant for employment, they have two options. One is to go through the BCA, which is a great option, but it does cost money and it does take a little extra time. Or they can go to their own city's police department and get access to criminal history data. That is not changing under this bill. The only thing this bill is doing is clarifying that the police department can give the relevant criminal history to the hiring authority rather than just a yes/no hire decision. So the decision is in the hands of the people at the city who are best able to make the decision whether to hire someone or not. So, for example, if the city is, if the applicant has a DUI, the city hiring authority could decide whether that DUI was relevant to the job. And it might be relevant if the person is going to drive on behalf of the city, but if it's an office worker who will never drive on behalf of the city, the DUI may be completely irrelevant to the job. And the person's best able to make those decisions are the hiring authorities themselves. So we would like to ask to have this bill go forward just to clarify that and make sure that our cities can handle these hiring decisions in a lawful manner. For example, the Equal Employment Opportunity Commission has various factors that an employer has to look at when they're trying to decide whether a criminal history should bar someone from employment. And again, the hiring authority is the best place for that decision-making to occur. I hope that clarifies that, and I think this is a small change that will just increase efficiency in the hiring process for our cities, and I'd be happy to answer any questions.
Thank you, Ms. Kushner. Any questions or discussion from committee members? Senator Latz.
This is something that would possibly caught me by the revisers, Mr. Chairman, but I'm just asking a question on line 1.21. Looks like the period at the end of the paragraph is struck through. Is it? Oh, never mind. I see the period on line 1.18 after the strike through of office is left intact, so that's the period for the sentence. I withdraw my comment.
Thank you, Senator Latz. Senator Limmer.
We're really getting picky now. Senator Koran, this is a bill regarding specific data on an individual. And we usually categorize or make reference in Chapter 13 regarding data privacy. I don't see a reference to Chapter 13 in this bill. So it's been an effort of this committee to keep referring these type of changes to Chapter 13 specifically, so it's easy for people to pick up on the subject. It's kind of cataloged in one chapter. This is the way this is written, it's in section 299. So I wanted to ask, perhaps not you, Senator, but council, is there a need to put a cross-reference to Chapter 13?
Ms. Primo.
Mr. Chair and members and Senator Limmer, there's not necessarily a need to put a reference because criminal history data is already classified as private data, and that classification would transfer over to the other government entity. It's already data that is collected and maintained, so Chapter 13 provisions already apply to that type of data.
All right.
Senator Limmer.
No, I have no further questions. Just
Okay.
wanted to raise it.
Any further discussion? Seeing none, Senator Koran, any final comments?
Thank you, Mr. Chair. We appreciate your support and brief consideration and comments regarding the bill. But this process is good governance. It streamlines the process and really gives the city the control they need, reduce a little bit of the burden on the BCA from these requests when they can take care of them within their own agencies. And along, we didn't mention earlier, but the groups that are aware of the bill and have no concerns are the Association of Minnesota Counties, Sheriff's Associations, Police Associations, and the Minnesota Council on Government Information. So broad support, and we would appreciate your support in passing this on. Thank you.
Thank you, Senator Koran. Senator Bigham renews her motion. That's Senate File 3214 as amended, be recommended to pass and referred to general orders. On that motion, all in favor say aye. Aye. Opposed, no. The motion prevails and the bill is passed. Thank you, Senator Koran. Thank you, members. There being no further business before the committee, we now stand adjourned.
Do that, Fred.